Tragedy struck the people of Costilla County, Colorado in 1960 when Jack Taylor fenced them off the land they call La Sierra. The county residents and their ancestors had long used this land to graze livestock, harvest timber, collect firewood, hunt, and fish. The people didn't take this lying down. They took Taylor to court. Although they lost repeatedly, they didn't give up. Finally, in 2002, the people prevailed. In a surprising ruling, the court granted them access. They had finally triumphed. The story of the Lobato versus Taylor litigation illustrates a community's ability to turn tragedy into triumph through collective action and perseverance. Eugene Lobato was a resident of Costilla County, a largely Hispanic, rural county in southern Colorado, which includes La Sierra. La Sierra is an enchanting 77,500-acre mountain tract filled with majestic peaks, fields, and meadows awash in flowers, and spruce fir forests covering slopes of yellow and orange aspen. Lobato was the first of more than 80 plaintiffs who brought the lawsuit on behalf of the entire community, so his name was used to represent them in court. The story begins in 1844 when the Mexican government issued the Sangre de Cristo land grant to a French-Canadian named Charles Beaubien. It covered 1 million acres in southern Colorado, including La Sierra. In 1848, the Mexican-American War ended with the Treaty of Guadalupe Hidalgo. Mexico gave the United States the territory of New Mexico, which included much of present-day southern Colorado, as well as La Sierra. In response, the U.S. agreed to honor existing property rights on the land they received. To encourage settlement, Beaubien promised that settlers would receive enough land for home sites, grazing, and cultivation. Over 100 mostly Hispanic families moved to the land, and their successors depended on La Sierra for their grazing, hunting, firewood, fishing, and timber needs. The Beaubien document, written in 1863, laid out the settlers' rights to accessing and using the land. The document stated that all the inhabitants will have enjoyment of pastures, water, firewood, and timber, always taking care not to injure another. The people settled in small towns. Life was often very hard. The people depended on La Sierra for many things. They celebrated festivals and picnicked on it. They gathered firewood on it. They grazed animals on it in the summer and cut timber for their houses and fences.
We used it very, very much for all sorts of things when we were children. My father would let us have his pickup, and I would take my brothers and my cousins, and we'd go up to Whiskey Pass and camp, build fires. We could tune in Japan on our shortwave radios.
Things changed in 1960. Jack Taylor purchased the area of the land grant that included La Sierra. On his contract, he agreed that he would honor the local settlers' rights to accessing and using the land, but soon after the purchase, he fenced them off.
Well, he was a timberman, and a real tough, hard-bitten timberman from North Carolina, and he was used to buying properties with problems of the title, and winning cases in court. And then he would have been a pilot in World War II, and he happened to be flying over southern Colorado one day and saw this mountainside filled with forest. So he found out about it, decided it looked like good timber, and he arranged to buy it. He had a very strong view that it was his property, and he had property rights, and he could do what he wanted with his property. And when the local people felt that they should have the use of the property because of the historical background, he got angry and put up the fence to keep them from putting their cattle on his land.
He then filed a legal action over 200 miles away in Denver, in which he sought the exclusive right to use La Sierra. In his words, Taylor is the owner by purchase of such land under deed dated February 15, 1960. Taylor has continuously paid the taxes on said land and has maintained sole and exclusive use and occupation thereof. The court ruled in Taylor's favor, which increased the community's economic challenges. Much of the population was below the poverty line, and many of the people in the county were without running water or electricity. Without access to La Sierra, they no longer had timber for building or firewood to heat their homes. Also, they had to eliminate or reduce their livestock, which was a source of food. From 1960 to 1970, 1 in every 4 members of the population would have to move away.
Their whole survival was either based on their animals, their livestock, as well as their crops. And because of its height and altitude and so on, and the amount of water, the need for them to have cattle and sheep and so on, and be able to take those herds up on the mountain during the summer was very, very critical to their survival.
In 1981, Rael versus Taylor was filed by an 83-year-old farmer by the name of Apolinar Rael, who was a member of a local group called the Land Rights Council.
in 1981, we had all of our research done, and we took it to the attorneys and said, now will you file a class action lawsuit? That was filed on March the 8th of 1981, and the rest is history.
He bought the land, and then he filed a lawsuit, and he got an order to wipe out the local people's rights, the local property owners' rights to go on the mountain. But he didn't name and serve everybody. And he had a requirement under our Constitution that if you're going to take away somebody's property rights under the 14th Amendment to our Constitution, it's called due process, a state court can't, or a federal court can't take away rights of somebody in property unless those people have a right to go to court.
In 1985, Taylor asked the court to rule in his favor on the ground that the community's claims were barred because of res judicata, which means that once a case has been decided, it cannot be retried. Both the trial court and the Court of Appeals agreed with Taylor and rejected the new lawsuit based on res judicata. The state Supreme Court decided to review the case, and it ruled in 1994 that the people could pursue their claims because it was unclear whether Mr. Taylor had given them proper notice of his earlier lawsuit. As New Yorker writer Calvin Trillin declared, a man sometimes owns only the land his neighbors acknowledge he owns. So the lawsuit continued, but after a lengthy trial, the trial court again ruled against the community. It decided that only 7 of the plaintiffs could pursue their claims for access, and that none of these plaintiffs had a right to use La Sierra. Taylor's son, Zach, stated, "Progress displaces people. Wagon wheels get displaced by automobiles. Everybody gets displaced." The people appealed this decision too, but the Court of Appeals agreed with the trial court. Once again, the state Supreme Court decided to review the case, and it issued 2 decisions in 2002. It decided that all of the people who did not receive individual notice of the Torrance action could pursue their claims, and that anyone who could trace their land back to when Charles Beaubien owned it could use La Sierra for grazing, timber, and firewood. Through March 2007, over 1,400 people have received access rights to La Sierra.
It's very difficult to describe in words the value of that decision. I get emotional because we've been in this struggle for so long, and we had so many decisions that didn't go our way. To hear that this decision came out from the Colorado Supreme Court was just amazing. It was the best day of my life next to the birth of my daughters.
People were stunned. We couldn't believe it. It was a miracle. So that's how I felt. It was the 21st century miracle.
My dad was one of the early that instigated this whole thing. Don't let it just be fight for your rights. Well, we waited so long for justice, and finally justice was served. When it happened, I came to see our priest at the church, and he said, "What do you know? Your dad is a happy camper now."
This case helped the community to come together as one and fight for what they all believed in. This case socially brought a different perspective on property rights. This case shows how communities can come together and fight for rights given to them under prior laws and documents. This case also serves as an example for other communities. It has been cited in 19 other court cases in Colorado and has been discussed in a number of scholarly articles in other states. One significant political impact was the use of the case by a group asking Colorado voters to impose term limits on judges in 2006. This group argued that the judges who had ruled on this case had made a terrible decision, and that the term limits would result in their removal because they had already served their full terms. However, the Colorado voters decisively rejected the term limit proposal.
Frankly, I think this is an incredible story, an incredible example of a tragedy and a triumph. And the tragedy was that this whole history, which is very unique to this particular area of the world, there was an attempt to quash this history and essentially to destroy this community. Now, as a result of the hard work between the legal team and the local community, that we're in the process, we're climbing the mountain now, literally and figuratively, of triumph. And it's a very, very unique story.